Live. So thanks for joining us for tonight's ethics webinar. My name is Conrad Stradom and I'm the editor of Medical Academic. We are joined tonight by Natasha Naidoo, who will present on medical record keeping, a healthcare practitioner's window of opportunity. Tonight's webinar is sponsored by Genoa Underwriting Managers, Indwe Risk Services, and MC de Villiers Brokers. Natasha is a senior associate in Norton Rose Fulbright's insurance litigation team in Johannesburg. She focuses on insurance litigation and general liability claims, more specifically medical malpractice and personal injury claims. All risks cover business interruption, subrogated recoveries and defenses, and product liability and recall. She also provides coverage advice to major insurers. Natasha has a particular interest in medical malpractice and personal injury matters. She represents most of the major private hospital networks and the Department of Health in South Africa in medical legal matters involving claims for cerebral palsy, retinopathy of prematurity, orthopedic and neurological injuries. She provides regulatory advice to private hospitals, both locally and internationally, on aspects concerning terms and conditions of admission, policy interpretation, policy review, and policy drafting. Natasha provides regulatory advice to major pharmaceutical companies and manufacturers of medicine and medical devices. More recently, she advised on vaccine laws in Africa in relation to indemnification and vaccine injury compensation systems, class actions, and product liability litigation in Africa. Natasha has performed risk assessments and advised on supplier agreements in relation to the procurement of the COVID-19 vaccine. Now for some admin. This webinar has been accredited for one ethics point. A PDF of your CPD certificate will be sent to you a few weeks after this event. To obtain your CPD certificate from this event, you will have to send an email with your name, surname, and MP number to john.woodford@newmedia.co.za. I will post that email address and these instructions in the chat box on the right-hand side of your screen. Again, please allow us a few weeks to process your CPD certificate and send it to you. And if you don't get a certificate in a month of the event, please contact me directly. I will post my contact details in the chat as well. If you experience a bad connection, there's a box at the top of your screen that says reconnect. Please use this button. It will bring you right back into the room if you have any connectivity issues. I will be posting a link to a survey about medical malpractice insurance in the chat. Please take the time to answer it. Furthermore, if you would like the sponsors of this webinar to contact you after the event, you are welcome to leave your email address in the chat. Please type all your questions or comments in the chat section. Natasha will answer your questions afterwards. There will also be a video replay of this CPD available where you can still get your ethics CPD point from watching the replay. Please note you will have to watch the full webinar to qualify for your point. And without further ado, over to you, Natasha.
Thank you, Conrad, for the introduction and a very warm welcome to everyone. I would like first to give you a rundown of what I intend to speak about today before I get started. I will tell you first about the types of claims that I have dealt with over the years. I will speak about medical record keeping itself, what constitutes medical records, what the characteristics of good records are, not only in relation to practitioners, but also to nursing staff. I will then go on to speak about informed consent, what the requirements are, and what the process of obtaining informed consent entails. I will also then give you examples of case law involving both. So in terms of the South African common law, a claimant may claim compensation arising from injuries, harm, or death suffered by the patient, which is due to the alleged negligence by a practitioner and the hospital. The claim is usually instituted out of the High Court having jurisdiction, and it is aimed at placing the patient in the position that he or she was in prior to the treatment received. The quanta of the claim can range anything between 7 million for a wrongful surgery claim and 15 million for a cerebral palsy claim. The claim against a practitioner in private practice will be against the practitioner who practices independently. The allegations are founded on an omission or an act or as a result of acts of negligence which deviated from the actions of the reasonable practitioner, who would have acted differently under the same circumstances. The allegation further is that the practitioner involved did not exercise the relevant skills and expertise required. Where the claim is against a private hospital, it is usually due to alleged negligence on the part of the nursing staff who are employed by the hospital. The allegations are based on the standard of treatment, care, and monitoring that's provided in the course and scope of their duties as employees of the hospital. Then in the public healthcare sector, the claim is against the MEC for Health. The allegations are founded on the same basis, except that the practitioners, including the doctors and nursing staff, would have acted in their capacities as employees of the hospital, which falls under the auspices of the MEC for Health. I also act for insurers who insure practitioners with professional indemnity cover. I represent practitioners in proceedings before the HPCSA. This is where complaints are lodged against them for professional misconduct. There is no monetary gain for the complainant, but rather the HPCSA will consider the response which is submitted. They may then decide that the practitioner is not guilty, in which case the matter is not taken any further, or that an inquiry must be held into the conduct of the practitioner, alternatively that the practitioner pay an admission of guilt fine. If a matter is referred to an inquiry before a professional conduct committee, the practitioner is provided the opportunity to plead guilty or not guilty to the charges that have been formulated. At the end of the inquiry, the committee will make a finding which might entail one of the following findings. It might be a caution or a reprimand, or both. Or a practitioner may be suspended from practice for a specified time period, or his or her name may be removed from the register. As an alternative, a prescribed fine may be imposed. The committee may also find that a compulsory period of professional service be rendered by the practitioner, and sometimes even costs of the proceedings may be awarded against the practitioner. Then there are criminal charges that may be instituted, and this is usually instituted by a patient or somebody else on behalf of the patient, and the NPA then assesses the case and then decides whether criminal proceedings should be instituted or not. An inquest is held where someone has died from unnatural causes, and depending on the findings of the inquest, the NPA may decide to charge the practitioner criminally. Then the state in a criminal trial is required to prove that the negligent act of the accused practitioner resulted in the death of or the harm caused to the patient. An accused may be convicted of culpable homicide if it is established that the accused acted negligently. I'd like to tell you about some of the types of claims for compensation for injuries that I have dealt with over the years. We deal with a number of cerebral palsy cases. The allegations are usually that there was a failure to monitor a patient's labor in accordance with the maternity care guidelines, in that fetal heart rate was not monitored correctly or sufficiently during the different stages of the patient's labor. Sometimes there's a failure to perform a C-section on an urgent basis where there is evidence that the baby had to be delivered urgently. The treating doctor did not consider the size of the baby's head in relation to the size of the patient's pelvis, and other factors such as maternal age were not taken into consideration. The result then is that the issue of cephalopelvic disproportion arises. Then there are also other cases which involve, for example, retinopathy of prematurity cases. Here, the allegations usually are that the premature baby was not monitored in terms of the South African guidelines for prevention of blindness. There was a failure or inadequate monitoring of oxygen saturation levels. There was a failure to refer the baby for screening at an appropriate stage of its life, which resulted in permanent blindness. Very often, we are told during our consultations with the hospital staff that this was all attended to, but it was not noted properly or at all in the clinical records. Then there are the cases where patients were admitted to undergo a specific surgical procedure and complications may arise, or the patient may develop a hospital-acquired infection. And here the allegations usually are that there was a failure to recognize biochemical markers of inflammation or sepsis, and the hospital staff failed to treat, for example, a cerebrospinal leak. The wound site was not properly cared for, resulting in bacteria infecting the wound. The patient then develops meningitis, hydrocephalus, and chronic sepsis, and this then requires prolonged ICU admission, which results in the patient acquiring a hospital infection. So the end result is that the patient who had been admitted to undergo a specific surgical procedure suffered all sorts of complications, even though the surgical procedure for which the patient was initially admitted was actually successful. Even in the most well-renowned hospitals in the world, it is not always possible to prevent a patient from acquiring a hospital infection. But it will only be evident from the clinical records of the patient that bloods were in fact taken every Monday to keep an eye out for infections. Where the instructions of the treating doctor are to delay the tests for whatever reason, the reasons must be noted in the records so that an inference is not drawn as a result of the absence of those reasons in the records. Because this is then viewed as an unnecessary delay in doing the blood tests. So one can only tell from the notes that are made that the wound care nurse attended on the patient on the dates and at the times noted. There are also cases involving incorrect diagnosis or insufficient treatment or care provided to the patient, which then results in pressure sores and septicemia. Protocols must be adhered to, and often this is not noted in clinical records. Very common also are claims against the doctors not attending to hospitalized patients timelessly. This is where a patient is under the treatment and care of a doctor. The patient's condition takes a turn for the worse, and the patient then requires, for example, mechanical ventilation. And according to the clinical records, the doctor didn't arrive timelessly or at all, or gives telephonic directions to the hospital staff. In such a case, the doctor was required to attend on the patient in hospital, but didn't do so. And that then results in the patient's condition deteriorating and the patient dying. Sometimes the doctor may in his defense plead that he did in fact attend on the patient, but there is no record of that because the notes weren't written into the clinical records. The only note then is the note that was made by the nurse who called that doctor that evening. So moving on now to medical records and what constitutes good medical record keeping. Healthcare professionals and facilities are by law required to keep contemporaneous medical records of their patients. What this then means is that the notes must be made ideally during the consultation with the patient or while attending on the patient or soon thereafter. According to the HPCSA guidelines, medical records, including the handwritten notes, notes taken by practitioners who treated a patient prior to the treating doctor, referral letters, laboratory reports, diagnostic X-ray reports, audio visuals, medical aid forms, death certificates, autopsy reports, informed consent forms, the last mentioned of which I will discuss in detail later. Emails, text messages exchanged, and any form of oral or written communications between the practitioner and the patient all form part of the patient's medical records, which must be kept. Where a patient is hospitalized, the patient's clinical records, including admission papers, stock sheets, fluid input-output charts, medical prescription lists, nursing and doctor's notes, And essentially everything contained in the patient file, including the stickers, the front, the back cover of the file, all constitute clinical records. So other than retaining the records for purposes of diagnosing a patient later on or for ongoing clinical management of the patient, medical records are perhaps the most important evidence in medical malpractice litigation. And this is simply because it is evidence of diagnosis, treatment, and care provided to the patient, all of which are now in dispute. So what are the characteristics of good records? Personal particulars should be recorded accurately. The patient should be afforded the opportunity to update details in patient information forms when they attend at the practice. As part of their training, reception staff should ensure that patients consider their basic information on file and make any changes if necessary to update the file. Then the biopsychosocial history of the patient, allergies, chronic medication which the patient is on should all be noted. The date, time, and place of every consultation is vital, and this should be noted on the records as well. Assessment details must be included. You should state precisely what your assessment of the patient entailed. Routine examinations, for example, the patient's temperature, heart rate, blood pressure should all be noted. The proposed clinical management of the patient, which would include the diagnosis, the options available to the patient with regards to treatment going forward. All of this forms part of the process of obtaining informed consent. Then medication and dosage prescribed, of course, must be noted. You may be of the view that it is necessary to prescribe, for example, the original form of a medication, and the patient may opt to purchase the generic at the pharmacy, which is why you should note that the original, in your view, was prescribed, because the prescribing the generic in certain instances may not attain the same result or may prolong the desired outcome which the patient seeks to achieve. Ensure that all of this information relating to the patient, including the blood test results, x-rays, results of any diagnostic tests, are all kept together in the patient file. It isn't entirely necessary to keep tax invoices and statements in the same file as the patient records. These may be kept separately. The other thing is referral forms or referral letters, rather, to another practitioner, which must be noted. This is where the patient says that they consulted another doctor who gave them a particular view, which you feel is perhaps outrageous or differs quite drastically from your own views. You should consider the previous medical records. You should use your discretion and give the practitioner a call to discuss the patient's case with that practitioner. And of course, all of this should be noted in the patient's records. Where you refer a patient to another practitioner, it is imperative that you note this and a copy of the referral letter stating why the referral is being made, what your views are, and what that particular practitioner should actually consider should be given to the patient, and a copy should be kept on your file as well. Something else that I have noted is that patients sometimes suffer from a condition or a disease and may say that they were predisposed to it because there is a family history which the treating doctor, who is also the family doctor, is fully aware of. It is important then to provide the patient with as much information as possible. This is where a patient may raise a serious issue which a family member suffers from or suffered from in the past, and you should advise the patient that they may even look further into it, even in circumstances where the patient doesn't really present with any symptoms or signs of the disease or the condition. The patient may, for example, be referred to a geneticist who can consider whether the patient is predisposed to, for example, breast cancer. Of course, it is important to make notes of all of this on the records. Then reactions to treatment and medication, and the fact that you inform the patient of the reason for the adverse reaction should also be noted, so that there are no allegations in the future that the patient was not informed of the reasons. Notes must be made legible and they should be easily decipherable. Further, it is not only important to note what you told the patient, but also what the patient told you during the consultation. So all and any advice given to the patient, any warnings the patient has been alerted to, follow-up consultations should all be noted. When things go wrong, patients may allege that they were not asked to return for a follow-up consultation, for example. There have been instances where parties have disputed where the patient was hospitalized, for example, who exactly was responsible for writing or transcribing each day's prescription in ICU charts. So was it the nursing staff or the intensivist on duty or the practitioner who prescribed the medication? And this usually occurs where there are errors in transcribing the list of medication in the next day's chart. Then where a patient is hospitalized and you are placing the patient under another doctor's care, whether it is for a temporary duration or not, you need to then brief the practitioner you hand the patient over to in detail and note this in the records. You should also inform the practitioner taking over what condition the patient has been hospitalized for, what medication the patient is on, the risk factors involved, what to look out for, and what the plan of treatment is. So the practitioner taking over should be alerted to certain issues that might arise, and this is due to the fact that you are the treating doctor, of course. Where a patient is critically ill and is in ICU, for example, and you're handing over the patient to another practitioner, it is good bedside manners to ensure that every member involved in the treatment of the patient is present when handover is being attended to, and that this is also all documented in your notes. So much of what I've said and what I've referred to thus far is in relation to good record keeping, and it applies to nursing staff as well as to the extent that nursing staff are required to make notes in patients' clinical records. But in addition to what I have already spoken about, it's important for both doctors and nursing staff to note the importance of good nursing notes. Nursing notes in particular should include an accurate account of treatment and care that is provided to the patient. Patient's involvement is necessary. The patient should provide an account of how he or she is feeling and should be urged to give meaningful responses and feedback where this is possible, of course. Notes should be made as and when observations are made in chronological order. Whatever is written should be comprehensive enough, basically, to allow a nurse who comes on duty to continue with the same treatment of the patient once the nurse who was attending to the patient has gone off duty. In other words, where there has been a shift change. Handover at shift change should entail a discussion during which the nurse who is going off duty provides a rundown of the patient's condition and informs the nurse who is coming on duty of any important issues that the nurse taking over the patient should be alert to. In considering whether a nurse was negligent, it must be clear from the records and the nursing notes that the nurse fulfilled all her duties and took all reasonable steps to care for the patient to the best of her ability. There should not be any evidence of an act or an omission on the part of the nurse which compromised the patient's safety. So it is very important that judgmental views and vague information is not included in the nursing notes. For example, where there have been instances where the nursing notes state that the patient repeatedly complains even though medication was given, or the notes say things like patient looks well today, Where a nurse disagrees with the treatment or medication prescribed, the nurse should obviously raise this with the treating doctor. There is a duty on the nursing staff where, for example, the nurse calls the doctor to advise that the patient's condition has deteriorated, and the doctor then informs the nurse to continue with the medication that was prescribed or take certain steps to, the nurse must then alert the shift leader to the situation or ask another doctor who is able to attend to the patient if it is an emergency to do so. This is where that nurse is of the view that the patient's condition is not improving. So it is not sufficient for a nurse to state in the nursing notes that, well, I called the doctor and the doctor asked me to continue with the prescribed treatment, and the patient failed to respond to the treatment, which then resulted in the death of the patient. Another thing is that when you look at the records, jargon and meaningless phrases such as patient slept well or the patient appears to be in a cheerful mood is not really necessary. All of that is basically speculation, and unless it is relevant to the patient's condition, it really serves little relevance in the records. Offensive subjective statements such as the patient is complaining of backache again as usual today should also not be included in the notes. If something is recorded in error, then a single line should be drawn across the incorrect information, and the nurse in question or the healthcare practitioner should insert a signature next to the note recording the date. A nurse should bear in mind at all times that any notes or records taken while he or she is on duty is a potential legal document which can be used in court. I would like now to speak about a few cases which are actual case law that were matters before the court where patients instituted actions. The first one is where an action was instituted against a private hospital and a gynecologist. The hospital was cited as the first defendant and the gynecologist as the second defendant. The patient was pregnant. She was admitted to hospital due to minor labor pains she was experiencing. She was examined and a birth plan was created by her gynae. 2 hours later, her contractions became stronger. Her waters broke. She did inform the nurse on duty of this, but it would appear that the nurse acknowledged what the patient said, but she didn't note it down in the records, and she was busy with another patient thereafter. The gynecologist then called an hour later to inquire from the nurse what the position was and whether the waters had broken, and the nurse answered in the negative. The gynecologist came in shortly thereafter and attended to the patient. Delivery was attempted via vacuum suction and forceps were used, and this was due to maternal exhaustion. And the baby was eventually born via normal vaginal birth. Expert evidence was presented during which both parties' experts were in agreement that the partogram wasn't plotted correctly, and that if all the relevant information was recorded correctly, a gynecologist would have been called earlier on. And even in the absence of the treating gynecologist being present, if dilatation was recorded properly, an emergency C-section would have been performed even by another gynecologist. It was clearly an emergency situation. The protocol was that fetal heart rate should be determined by doing CTGs every 30 minutes during the active phase of labor, but no CTG tracings were available for the most crucial part of the patient's labor. The nursing staff then claimed that the gynecologist prescribed medication that was contraindicated, and it in fact had the effect of speeding up the patient's labor. There was nothing in the clinical records regarding the time when it was given, at which stage it was given, by whom or how it was administered, what the dose was, who gave the instruction, and whether there was any fetal heart rate monitoring during this period, all of which was very crucial. The doctor denied prescribing the medication, and it was then the nurse's words against the gynecologists. The court in this case held that the medical record keeping as a start was appalling. The monitoring was not in line with what was prescribed in the maternity guidelines. If proper observations were made and recorded, an emergency C-section would have been performed much sooner and the final outcome would have been avoided. So the baby suffered birth asphyxia and a hypoxic insult to the brain, which was of a partial prolonged nature. And the cause of the type of insult to the brain was as a result of prolonged labor and the fetal distress that went unnoticed. It was common cause that the fetal heart rate should have been monitored every half hour, but it was monitored only on 3 occasions since the patient's admission to the hospital. The court in this case held that the negligence of the nursing staff and the failure to monitor resulted in the baby's cerebral palsy. Further, that the gynecologist was liable for failure to attend on the patient timelessly. The next case, this was a case against the MEC for help. So this was where a patient instituted action against the defendant in her personal and representative capacity as the mother and natural guardian of the minor child. The patient's case was that she attended at the clinic. She was transferred by ambulance to the hospital. She endured several hours of labor, and a C-section should actually have been performed much sooner. The child was eventually born by a normal vaginal delivery, and due to the prolonged labor and the failure to timelessly perform the C-section, the child suffers from cerebral palsy, mental retardation, and epilepsy due to the asphyxia which occurred during the labor. There were absolutely no clinical records available at all. There were also no CTG tracings available. The entire patient file containing the antenatal and the labor records had been misplaced. As a result, the patient's version of the events that transpired was the only version put before the court. So none of the hospital staff could remember the matter, which was understandable, and the patient was regarded as the only factual witness in the case. The evidence of the patient, and which was actually supported by the parties' experts who reconstructed the events that transpired and which most likely resulted in the brain damage, was then put before the court. With reference to the clinical records, the court stated that the medical records of the patient were crucial and completely indispensable. Legislation imposes a duty on a healthcare practitioner or an establishment to keep and store meticulous medical records. CTG records constituted the original and foundational documentary evidence of the patient, and the subsequent noting of the information that is obtained from the CTG and is then put onto the partogram, and any evidence given in support of the CTG findings actually constitutes hearsay evidence. So no explanation was offered for the missing clinical records, and the court stated that it was not the problem of the patient if the hospital misplaced the records. And the court in this case held in favor of the patient. Moving on now to informed consent. As you are aware, it is a patient's rights, which flows from various legislation, including the Constitution, to be placed in possession of all information that is necessary for the patient to make an informed decision on any issue. Informed consent must be obtained when prescribing any forms of treatment or undertaking surgical procedures. It is imperative that you maintain records of the patient, providing informed consent on the patient file. In fact, you should have an informed consent form for the patient on the file, which has been completed by yourself and signed by both the patient and you, the practitioner who obtained the informed consent. The form serves as evidence that all requirements for purposes of obtaining informed consent has been met. So what are the requirements then? it is a requirement that an actual discussion be held with the patient, during which the patient is informed of all conditions which he or she has been diagnosed with. The patient must be informed during this discussion or consultation precisely what options are available, where there are different types of medication that might be available to the patient should be informed of these types of medication. A recommendation should be made, of course, having regard to what the best option for the patient is. Where there is an alternative to surgery, the patient must be informed of what these alternatives are. So often a doctor will say, I prescribed X and Y because I knew that the patient couldn't afford the treatment, which would be more effective, or, the patient had ran out of medical funds and things like that. But the patient needs to be informed irrespective of all available options. If there are different procedures that can be performed on the patient should be informed of this, what the procedures are and what is most suitable in the practitioner's views and why this is the case. The practitioner is required to inform the patient similarly of the risks and adverse effects associated with each option. So it is not necessary to go into details like you would find in package inserts of medication boxes, but the most common side effects having regard to the patient's condition should be communicated to the patient. On a similar basis, the patient should be informed of the benefits of each option. The patient must also be informed of the costs associated with each option, irrespective of whether the patient chooses option A or B. This is simply because patients have alleged in the past that they were never informed of a certain option. The patient then informs us, or the practitioner then rather informs us, that the patient was out of funds, as I said earlier, which is why it was never suggested. So withholding this information is not actually helpful when faced with a situation where the patient says that they could have obtained the funds from a friend or a relative and paid for the treatment had they known about the option. And lastly, the patient should be provided with the opportunity to ask questions which the practitioner is obliged to answer. All the information provided to the patient will then place the patient in a position to make an informed decision. And of course, the informed consent form, which is signed by both parties, should form part of the healthcare records. I will speak about one case which involved informed consent, and this was an action that was instituted by a patient against a general surgeon for alleged failure to provide her with the necessary information that would have enabled her to give informed consent to a laparotomy procedure to prepare a hernia. The doctor's case here was that he had a discussion with the patient and he provided her with the information regarding both options available to her, being a laparoscopy and a laparotomy. He recommended that the laparoscopy was the better option due to the risks and benefits that were associated with both. And he informed her that the laparoscopy could actually result in bowel injury, but that the laparotomy involved open surgery. He also informed her that the laparoscopy could actually result in him having to perform open surgery on her if needs be. The patient provided him with informed consent to perform the procedure as recommended. But when things went wrong, the patient's case was that the doctor made a decision to perform the procedure at the very first consultation with her. So that was at the initial consultation that he held with her. She said that the doctor didn't provide her with any information relating to the options available. The doctor did not inform her of the risks, the benefits associated with each procedure, except that he informed her which of the two options was the better option to go with. So as such, he made a recommendation based on his knowledge alone and without taking her views into consideration, or at least these were the allegations against him. She then said that Had she known, she would have chosen the option which was less risky if the doctor provided her with all the information that was necessary to make an informed decision. The court held here that a patient must have knowledge of and must appreciate the nature and extent of any harm or material risk. Doctors are obliged to warn the patient of the material risks associated with the available procedures. A risk is considered material if a reasonable person in the position of the patient is warned of the risk and would attach significance to it, or where the doctor is aware that the patient, if warned, would attach significance to that risk. The doctor failed to record the discussion, unfortunately, which he had with the patient. So it wasn't on the medical records. But the court found in his favor simply because the version of events provided by him was consistent with a letter which he had actually written to the patient's medical aid, motivating why the procedure should be carried out on the patient and advising exactly what the risks and benefits of each option were. So this information supported the doctor's claim that a meaningful discussion had in fact taken place. I think it's necessary for me to touch very briefly on patients' access to their records and the confidentiality involved in patient record keeping. Every patient has a right to access his or her records. That's in terms of the Promotion of Access to Information Act. The records are not owned by the patients. The records remain the property of the person or the establishment that has created the records. But generally, patient records are a paper collection of the records contained in a file. However, hospitals are considering electronic record keeping so that patients are more in control of their records. It will require patients and practitioners to consent to electronic storage of the patient records. And of course, there must be compliance with other legislation such as the Protection of Personal Information Act. The current position is that if a patient requires copies of records, a request must be made in writing for the establishment or for the practitioner to consider before deciding to release the records. When it comes to discussing the patient's condition with relatives or with the next of kin, it's important to note which family members are involved in the patient's life. If it is an elderly patient, you need to find out from the patient whether the patient is happy that you liaise with the children or with siblings regarding the patient's condition. In such an instance, it's also then important to determine which family member is involved in the decision-making process and who will provide consent where the patient is unable to do so. All of this needs to be recorded in the patient file. It is also imperative then to note that the records must be kept for a period of no less than 6 years, ordinarily. Where the patient has a disease that has a slow progression over a longer period of time, the records should be kept longer. For example, where a patient is suffering from asbestosis, the recommendation is that the records be kept for 25 years. A minor's healthcare records should be kept until the minor is 21 years old. In the case of a mentally challenged patient, those records should be kept for the entire duration of the person's lifetime. So how do we mitigate the risks of record keeping where practitioners are faced with saving lives under highly pressurized circumstances on a daily basis and in a very busy environment? It really doesn't matter whether the notes are handwritten or whether they are kept electronically for litigation purposes. All that is required is that the records are stored safely and that a practitioner keeps legible, contemporaneous medical records of the patient, from which the practitioner or any other person, such as myself or a court, is able to determine what precisely transpired. As I mentioned earlier, notes should be made contemporaneously or in real time. meaning that it should be made immediately while consulting with the patient. And where this isn't possible, and that is of course understandable, for example, where you're doing ward rounds or where a procedure is being performed in theatre on the patient, this should be done as soon as possible thereafter. Dictating notes to be typed up by a secretary might be helpful, where the practitioner is doing ward rounds or even consulting with patients in rooms. So brief handwritten notes may be made, and at the end of the consultation, the practitioner may take a few minutes to dictate the notes, and most mobile devices allow for this. There's an app available on the device. There's always the concern regarding the accuracy of the notes then, having regard to the fact that it is typed up by somebody else. But this can be eliminated if the secretary, for example, is able to cross-reference those dictated transcribed notes to the brief handwritten notes, or the secretary may even clarify the position with the practitioner. Often notes are made retrospectively, and while this is allowed, it is not advisable, even though it cannot be avoided in its entirety. So regarding informed consent, my advice would be to ensure that the informed consent form is completed, having regard to everything that I have said earlier, and that you keep a copy on the patient's file for future reference, and the patient is also given a copy. I did read an article recently, and it was quite interesting to note that when asked what some of the barriers were, 76% of practitioners said that it was too time-consuming to make comprehensive notes. 51% said that they were very busy. 18% said that they lacked computer skills. 46% said that it is a matter of habit and that they kept records in a particular manner and it worked for them. 8% said that they are unlikely to receive a complaint or a claim against them. And 33% of them said that they lacked the requisite training. I think that good record keeping is an administrative task. It's tedious, and it is a matter of actually getting into the habit of doing it correctly. It should be considered part of the treatment process of the patient. Training and workshops should be held on an ongoing basis so that practitioners, including nursing staff, are alert to all the requirements when it comes to record keeping. I know that the Department of Health issued guidelines for filing, archiving, disposing of healthcare records, and how to properly note records. To attend a once-off training session, I don't think is sufficient. It should be on an ongoing basis from time to time. Training sessions should be attended. They should be put into practice. And to the extent that a particular method of note-taking or making does not work, give it some thought and implement a new plan of action that actually works for you. In the same token, refresher courses should also be attended by hospital staff and practitioners because legislation is constantly changing. You learn a lot from case law, and it is important to keep abreast of the latest developments. From a legal perspective, attorneys dealing with matters are faced with various difficulties in medical malpractice claims. There are sometimes no medical records available. The file is lost. We are unable to defend the action, and the client must then consider conceding liability due to the lack of evidence in support of the client's defense. Then there is the case of illegible entries. Sometimes important information is missing from a file. For example, in a case where a baby has suffered birth asphyxia, and the allegation is that there was lack of monitoring, for example. The hospital staff failed to realize that there was fetal distress, such as in the case law, which I referred you to earlier on. The importance of the CTG tracings are highly relevant there. Where they are missing and fetal heart rate has not been recorded in terms of the guidelines, This is problematic because the guidelines, even though they are merely guidelines, set out the intervals at which a patient should be monitored and the duration of the monitoring. Then there is the issue of the records of one patient getting mixed up with the records of another patient. It is important also to note that in a court case, edited records is evidence of inaccuracy and tampering, and it may be viewed as such. And it is therefore important to ensure that entries are recorded correctly, or where there are errors, then these errors are also rectified, as I stated to you earlier on. I also mentioned earlier that it is important that all members of a multidisciplinary team who is involved in the treatment and care of the patient records notes to the extent that they were involved, and how exactly each person on the team attended to the patient. It is also important to note, and it's also important to remain informed of all developments, not only in terms of legislation applicable, but also to consider the internal protocols and procedures in place by the hospitals where you practice. Very often they have specific protocols in place for treatment and care of patients in different wards. For example, the wound care protocols or pressure care or ICU protocols that they may have. And I think that this can only be achieved through practice and implementing a plan of action which is adhered to by the practitioner and the nursing staff. And it's important to always bear in mind that it is not only important to treat patients and for patients to make a good recovery, but that you keep record of the treatment provided, which is evidence of your role as a healthcare practitioner. That concludes my talk. I'm very happy to take questions, and I see that there are questions.
So do you see any of the questions, Natasha?
Yes, I'm looking at the questions, sorry. Yes, so there's various grounds on which a party can actually be denied access to the records. This is where a court feels that it is not in the interests of the person, where a court order has been handed down prohibiting a particular person from obtaining a copy of the records. But generally speaking, if an application is made for the records and the patient has consented, then it will obviously be granted. Refusing access to disclose the records, I don't think it is only the relevant person who would have to actually say that I am not consenting to it. The institution which holds the records would obviously want to look at authorization by that person, and there must be a good enough reason. And furthermore, sometimes even where the patient actually refuses to release those records, where, for example, there was a pandemic and it's in the interests of the public in general, then it will be released as well. I hope I've answered that question. Records should be kept for 6 years. Yes, that is correct. The record of minors should be kept until their 21st birthday. Correct. Patients mentally impaired should be kept until death. That's correct. I haven't referred to the citations of the cases because some of them are reported cases, but obviously for the sake of confidentiality, I haven't actually referred to the full citations. What do patients have access to from their file in terms of a file of the GP? As I said earlier, they have access to everything, but of course they may be provided with copies of the records, not necessarily with the originals. Where there is a court case involved, it is important that the practitioner has the original records, because this is for purposes of verification if the matter proceeds to trial. So you can provide the patient with copies of all their healthcare records, but bear in mind at all times that those records actually belong to the person who made the records. The next question is, what happens when you stop working? Must you still keep records? So yes, you should keep the records in accordance with the guidelines prescribed by the HPCSA. It might be that the patient goes to another healthcare practitioner and requires treatment and needs access to those records at a later stage, in which case you should keep those records. Obstetrical records should similarly be kept for a period of 6 years. So what are the examples of electronic record keeping? So this could have gone into quite a lengthy talk if I went into electronic record keeping. There are programs and applications that are in use. This is more so in the first world countries. It's something new in South Africa, but the health insurance schemes are making use of electronic copying or storage of records. It would have to be in read-only version, so you can't edit it or type over it. There would also have to be a backup made of the CD-ROM or CD drive so that it can't be changed. Paper records, yes, there is a time period within which it can actually be destroyed. I think the Minister of Health issues directives on that type of thing. Okay. Yes, yes, so the records should be encrypted, of course, and saved to a backup iCloud service, for example, with everything, including the patient's results, as you say, the reports, the notes. No hard copies will be kept, and this is a bit difficult for many people to digest because people often worry about what the consequences will be if there is a crash in the system. But that is why it is imperative that there be some sort of a backup in place. I think the rest of the questions now relate to issues that were experienced during the talk itself. But if there are any other questions, please do feel free to post them again.
I see this one. Are scanned records acceptable for long-term storage, or must it be hard copy?
Yes, scanned copies, of course, can be uploaded. As I said, you know, it's important when deciding on how to go about storing the records. You know, I think the records need to be kept, and the clinical manager of the hospital, who is usually tasked with keeping these records are within the control of the clinical manager, that such person be in the position to say at some stage, if the matter goes to trial, that I can swear on affidavit basically that these are the original records, because what actually then constitutes the original? For example, if our opponent wants to examine the records, they would want to look at it to verify the correctness of the records, that these are in fact the originals, because they would have been provided with copies of the records. So in such an instance, one would have to consider what are originals in the case where the originals themselves are not stored and scanned copies are uploaded to the system. So then I would think that if the clinical manager did go on affidavit and say that the scanned copies constitute originals, then that would suffice. Further down, I don't see any other questions. Conrad?
There are a few at the top. If you scroll to the top of the
very informative. WhatsApp. Okay. Were there complications? Which case was this being referred to? Well, in the cases involving the delivery of the babies, there weren't actually complications. So there weren't actually situations where the mother had a condition such as cephalopelvic disproportion or where shoulder dystocia suddenly presented. These cases dealt specifically with fetal distress, and all of this had gone unmonitored. So there were no complications as such. And usually the type of insult to the baby's brain points towards what exactly transpired. So you will find that where the injury was a partial prolonged injury, then it points towards fetal distress over a prolonged period of time. Where it's an acute profound type of injury that is evident from the scan, then it's usually something that transpired towards the end, the very end, the last 30 minutes of the delivery, and you can generally tell that something happened at that point which resulted in a delay, such as the cord being wrapped around the neck or whatever the case may be. Was the baby affected or the mother harmed? Yes, the final outcome for the baby was that the baby suffers from cerebral palsy today. The mother was not harmed in any way. And then we've obviously got to deal with the defense of the case in terms of liability of the defendant, which is usually the hospital and or the healthcare practitioner, and then the quantum trial, which involves payment of compensation. I didn't have slides, so I don't think that slides generally work in webinars, but yes, so I didn't have any slides, so I didn't share my screen for that reason. With regards to patient clinic note record keeping, is it acceptable to save an individual patient file on an encrypted? I think I've answered that already. I think I've answered everything. Against speech therapists, okay, there's a question as to whether there are any claims against speech therapists. No, I have not dealt with any claims against speech therapists thus far. Is it appropriate to pay for the records in a case when it is requested? Yes, the reasonable photocopying costs should be paid for. Even if you are a patient who is requesting the records, the hospital may request for the costs of those records being made. How are we expected to keep WhatsApp messages, print them all out, or note WhatsApp? Well, you could take a screenshot of it and then email it to yourself. Or you could also, I think WhatsApp makes provision to email a chat. I'm not sure whether it still has that available, but I do recall that. But yes, you could take a screenshot. Very often we receive screenshots which form part of the medical records, and you see the WhatsApp messages exchanged between the parties. Other question, in the case of a patient's death and the family asks for the file for insurance purposes, why is it that the request will be denied from the hospital side, saying that the family are not allowed to get a copy of the file? So this is where the patient has died. I think the expectation is that the request would come from the attorneys or the administrator of that estate, or whoever is the appointed as the trustee. That is the reason. So it's not possible for just any member of the family, the person who has been appointed in terms of the will, and whoever is nominated would have to actually apply for it. That's the reason. And they would then have to obviously present the certificate which confirms the position. Voice notes similarly may also be uploaded to or emailed to yourself. The next question, what must I do if a patient asks me to destroy their records? Well, use your discretion. If you think that the records might become important at a later stage, for example, you had a difficult patient or there were various queries from other members of the family, then keep it. But use your discretion and decide whether you will destroy the records or you will keep it. As I said, the records belong to you, and you should keep it for as long as you think it is necessary. The other question, any claims against pharmacists? Yes, pharmacists, there have been claims against pharmacists for the incorrect dose that is given to the patient where they couldn't recognize the handwriting, or they were unable to decipher the handwriting of a particular healthcare practitioner, what the prescription said. In such an instance, it is then the duty of the pharmacist to clarify the position with the healthcare practitioner by calling him or her. You cannot just, look at a script and then say, well, this reads like something in particular, and then prescribe or actually issue that medication. It could have a really bad effect on the patient, of course. What about a case where the patient has not paid fees for their consultations and procedures? Are we still compelled to provide records as and when they request it? Well, generally, it would also depend on who's asking, but payment would have to be made before records are actually released, unless there is a court order authorizing the release of those records. But generally, yes, patients are required to pay for the consultations before you can release any records. Where it is an emergency situation and another healthcare practitioner or an establishment has asked for the records, then there you would obviously use your discretion again and consider releasing those records, simply because it might be a matter of life and death.
I just want to mention that we are over time, so you've been speaking for much longer than an hour. If you don't want to continue answering questions, that's fine. There are a few more. Do you want to end the webinar? Or answer a few more?
I can answer a few more, maybe one or two more. And if anybody has any further questions, they're welcome to email them to you, Conrad. I think my email address, you also have my email address, so they may contact me as well, whatever they prefer. Do we have to change our normal SOPs when POPIA comes into effect if we already did everything correctly in terms of the older legislation and guidelines? Well, this would depend also on what regulations are issued under POPIA and whether it is necessary for you to then change. Yes, so that would entirely depend on whether there are any regulations that have been issued, but you would have to comply then with the Protection of Personal Information Act, which is why this time period has been provided before it comes into effect fully. Okay, Conrad, you're welcome to send any questions to my email address or to give my email address to anybody who wishes to ask any questions. I'm more than happy to answer.
Great. Thank you so much, Natasha. That was an excellent presentation. I'm getting a lot of compliments on email. Thank you so much, everyone that attended. A replay link will be available as well that you can send to people you know. They'll still be able to claim a CPD point for attending the replay as well. Again, thank you so much, Natasha. Thank you, everyone, for joining us tonight.
Thank you, everyone, for attending.
Yeah, goodbye. Thanks, bye-bye, everyone.